Good afternoon, everyone, and welcome to today's webinar. We are thrilled to have you join us. My name is Sarisati Khatakul, and I will be one of the speakers in today's event. Today, we will be diving into the Thai custom procedures, control of export, import, and transit of trademark and copyright infringement goods, and a subject that is both timely and important. We are confident that you will find the insights shared today valuable and thought-provoking. I am honored to be joined by our expert speaker, who brings a wealth of experience and knowledge, Khun Sukontip Mongkolthong, a partner of IP Enforcement Department here at Diligent Gibbons. Before we begin, just a few housekeeping notes to help the session run smoothly. Please note that this webinar is being recorded, and all applicants are currently on mute to minimize background noise. We encourage you to engage with us by asking questions. Please use the chat function located at the bottom of your screen. All questions will be addressed at the end of the session, and if we run out of time, we will follow up via email. Your feedback is incredibly important to us. At the end of the webinar, a QR code will appear on screen. Please take a moment to scan it and share your thoughts with us. With that, let's get started. I will now hand it over to Khun Sukontip to begin the presentation.
Okay, good afternoon, everyone. To provide you a roadmap for our discussion today, we will first introduce the updated Thai Custom IPR Recordation System, or known as TCIRS, which serves as the primary platform for recording intellectual property rights with Customs Department. We will outline the documentation required to discuss the advantages and disadvantages of the system, and review the legal provisions that underpin these procedures. In addition, we will explain how Customs address suspected infringing goods, both through its own initiative and upon request from right holders and case studies. We will also address the unique issues presented by patent infringing goods, present enforcement statistics, and highlight ongoing training efforts for authorities. So I would like to hand over the first topic to Khun Sarisa.
Next, I will talk about the updated current TCIRS system, which is a custom recordation in Thailand. TCIRS is short for the Thai Custom Intellectual Property Recordation System. It is a platform developed by the Thai Custom Department to help IP right holders record their trademark and copyright for proactive border enforcement. By submitting their IP information through TCIRS, right holder enable custom officer to identify, detain, and prevent the importation or exportation or transshipment of counterfeit or infringing goods at Thailand border. And as shown here, it is an example of the TCIRS webpage. As you can see, they will show the required application detail that must be completed. For example, you must choose whether this is a copyright or trademark, and you must fill in the application number and registration number. And as you can see, most of the information here is in Thai. Therefore, we recommend that you authorize a local representative or lawyer to act on your behalf for the recordation process with Customs. And this is an example of the status of the recorded application. As you can see on the right-hand side, there will, in Thai, it is recorded. Since the implementation of the TCIRS system since 2022, there have been over 1,500 entries with more than 1,300 applications accepted for recordation as of June 30, 2025. This demonstrates a proactive approach by right holders to safeguard their IP right at the border. The TCIRS platform has replaced the previous custom recordation system in Thailand. Applications submitted under the former system are now invalid, and the old database has been deleted. Therefore, the right holders are encouraged to record their registered trademark and copyright with this current system, TCIRS. After it has been operational since 2022, it continued to evolve and offering enhanced security and user friendliness. Only authorized individuals may access sensitive information, ensuring that confidentiality and integrity of the data provided. These are the new features of the TCIRS. It allows for applicant to amend submitted information or document, change their designated representative, and renew their recordation every 3 years. These features streamline the process and help ensure that custom officers have access to the most current data. For instance, if a power of attorney, POA, or trademark registration expired after the custom recordation, the updated documents such as a new POA or a renewed trademark certificate must be submitted through the TCIRS platform to maintain the validity of the application. And these are the required document and information. The applicant must provide several essential lists of document and detail, which we outline over here. First thing is the contact detail of the right holder or their authorized representative. This include name, address, email, and if you would like to appoint Gilligan Gibbon as a contact person, we will prepare this information on our own. And next is the IP ownership proof for the registered trademark or copyright. For trademark, a certificate of registration is required to be submitted. For a recorded copyright work in Thailand, with the Department of Intellectual Property or DIP, we will require certified copy of copyright recordation certificate. And what about copyright that is registered or recorded elsewhere in Thailand or not registered at all? Well, for those copyright work, it can also be recorded in the TCIRS platform, but you will need to provide to prepare an affidavit, including the copyright detail, which must be signed by the right holders. And don't worry, if you file the custom recordation with us, we will help you draft an affidavit for this. Additionally, applicants must supply information about the genuine goods and guidance on identifying counterfeit goods in the form of statement. And you will also be able to provide photo, documents, or any materials that you would like to provide. And this is one of the strengths of this system. The information may be in a form of simple thing that can be used with all the goods. For example, if all of your goods are manufactured in Japan, you can indicate that every piece of good will indicate made in Japan. Therefore, if the custom officer found any of your good indicating otherwise, then they can assume that that is fake. And in addition to the, you will also have to provide the identification document of the right holder. If you are an individual, an ID card or passport will be required. However, for company, if you are a Thai company, company certificate issue no later than 6 months needed. However, if you are a foreign company, a company certificate which issue longer than 6 months is acceptable. And if an agent is acting on behalf of the right holder, a signed and notarized POA is required. This requirement facilitates the accurate and efficient identification of infringing goods by custom officer. Next is the application process. The first step is gathering all the necessary document and information. Next, complete the application form on the TCIRS platform and upload all the required documents. Subsequently, you will need to schedule an appointment with the custom department and submit the hard copy printed application and meet with an officer in person. The officer will review the submission, and if it is completed, the application will be accepted. If any information is missing, the applicant will be asked to provide the missing details and information, and they will need to reschedule the meeting. This process ensures that only complete and accurate applications are processed. If you file a custom recordation with us, the only step that you need to do is providing us with the required information and document. After that, we will take care of all the other process for you. And upon acceptance, the custom recordation will remain valid for 3 years. Should the trademark registration expire during this period, a renewal certificate must be submitted to maintain the recordation. Renewal of custom recordation is permitted, provided that it is completed no later than 30 days prior to expiration. And any changes to the information provided must be reported via the TCAIS platform to ensure that all the recorded information is the most updated one. It is important to note that right holder will bear responsibility for any damage that may arise from action taken in good faith by custom officer during the inspection based on the information provided. If goods are erroneously detained, the right holder may be liable for damage incurred to the exporter, importer, or even the custom department. So please be sure to record the most updated information to mitigate the risk. And this is the pros of the current practice TCIRS. It is that this will be a direct filing with the custom department. This is an improvement compared to the prior practice, which people need to record their right with the Department of Intellectual Property, which is a DIP, and they need to forward the information to the custom. However, in this current practice, we can record information directly with the custom department. And the next pros is that your information and document will be secured and it will remain confidential. Only custom officer and the applicant can access the submitted data via the TCAIS platform. Other person cannot see it. And another pro is that they provide a flexible submission format. In addition to a written statement, right holder can upload image, document in form of PDF or presentation slides. This will help being a guideline to aid enforcement. And it provides a streamlined procedures with the exact time frame that we can expect. And next, compared to the prior practice, there is no requirement for the submission of liability consent because it will be automatically indicated in the TCIIS platform. Next is the cons. In case the custom officer initiated an ex officio action based on the information received from the TCIIS platform, and there are in case where the right holder are required to verify the detained good, they will have only 3 days after receiving the notice of custom officer. This is a little bit strict response timeline. Next is that ongoing information update. The right holder must ensure that all information recorded are most updated. So the right holder must bear the duty to keep updating their information. And next is the liability for good faith action. Next is the advantages for recording with custom. You might question, oh, there are some cons. Then why should we record it? So we will let you know that there are several key advantages for recording these. First, it will serve as a basis for ex officio action, meaning that custom officer can proactively inspect and seize suspicious infringing goods without the need for a prior complaint. These greatly enhance the efficiency and responsiveness of border enforcement. Second, it will help build greater confidence in the procedures undertaken by custom officer. When your rights are recorded, officers are better informed and better equipped to identify and act against suspicious shipments. Another important benefit is that the recordation applies not only to imported and exported goods, but also to goods in transit and transshipment. This is especially relevant in cases where Thailand may be used as a transit hub for infringing products destined for other countries. Additionally, shipping documents like invoices and bill of lading can help custom officers generate valuable intelligence about the origin or destination of the infringing goods, supporting broader investigation. And finally, successful seizures at the border can lead to civil action against the importer, allowing right holder to pursue compensation through legal proceeding. In summary, recordation with custom is a low-cost, high-impact strategy to strengthen enforcement and proactively protect your rights at Thailand's border. Next, we will talk about the legal framework supporting the custom procedures. Custom jurisdiction extends across 47 custom houses and 8 custom bureaus throughout Thailand, encompassing major ports and airports such as Bangkok Port, Lam Chabang Port, Suvarnabhumi Airport. This extensive coverage enables the effective detection and interception of infringing goods at numerous entry and exit points nationwide. These are the key ports under custom surveillance. Include the first one, Klong Tei Port, or another name is Bangkok Port. It's located on the left bank of Chao Phraya River. It is Thailand's first international port. However, as trade expanded, this river port could no longer accommodate large vessels. Consequently, a new port was constructed on the eastern coast. Currently, this port primarily focuses on domestic transportation. And next is Lam Chabang Port. It is a major deep sea port for international cargo transportation located in Chonburi province, serving as a central hub that connects Thai market with the global economy. It is recognized as one of the most efficient ports in Southeast Asia, handling both import and export shipments. And next is Suvarnabhumi Port. It is the largest airport in Thailand. It plays a vital role in international aviation, providing air transportation service for both passengers and cargo. Next is Mae Sai Port. The border crossing between Thailand and Myanmar serves as a key gateway for both trade and tourism connecting Myanmar and northern Laos. And next is Aranyapatet Port. It is a border checkpoint located in Satkhel province, adjacent to Cambodia. It serves as a permanent crossing point for the import and export of goods. And last is Nong Khai Port. Nong Khai Port plays a vital role as a transportation link for goods and passengers between Thailand and Laos. With the launch of the Laos-China railway service, the volume of cargo and passenger transport has significantly increased. To understand how Thailand enforces IP rights at its border, it is essential to look at the key legal instruments that form the fundamental of custom enforcement. First, we have the Custom Act, which provides the overarching legal framework for custom operations, including the authority to inspect, seize, and penalize goods that violate Thai law. Next is the notification of Ministry of Commerce regarding counterfeit and pirated goods prohibited from export, import, and transit to and from Thailand since 2022. It includes items bearing fake trademark and unauthorized use of copyright content or infringing packaging containing an explicitly prohibited of the export, import, transit, or transshipment of counterfeit or pirated goods. These regulations align with Thailand IP enforcement with international standards and define such goods as prohibited. And last is the most recent and impactful update. It is a Custom Department Notification number 106. It is effective in 2022. This notification introduced updated procedures for recording and handling goods suspected of trademark or copyright infringement. At this stage, I would like to emphasize custom power to seize goods at the border under the Custom Act. Section 4 of the Custom Act defines prohibited goods as items that are not allowed by law to be import, export, transit, transship to Thailand. It is important to note that goods infringing trademark or copyright are considered prohibited goods under the Ministry of Commerce notification. The Custom Act states that whoever import, export, transit, or transship goods and seek to avoid any restriction or prohibition is violating Section 244. The penalty can be imprisonment for up to 10 years or a fine up to 500,000 baht or both. Anyone who attempts to commit this act will also face the same punishment. And the court also has the authority to seize such goods regardless of whether any individual is found guilty at the court judgment. And next, Kun Kontip will talk about the custom procedures.
Yeah, I would like to talk about the custom procedure, about the detention procedures. Under the current custom notification, there are two scenarios which the custom would detain the suspicious counterfeit or infringing goods, export, import, and or transit. First scenario is an ex officio action. In case where custom officer have reasonable grounds to suspect that imported, exported, or transited goods may infringe trademark or copyright based on information submitted by the trademark and copyright owners in the custom recordation system or TCARS. The custom officer, they have authorities to seize such goods and detain the goods. Therefore, the custom may detain or seize such goods at the border and or the warehouse. For the second scenario is the inspection of goods upon request on a case-by-case basis. The trademark or copyright owner or their representative can submit an inspection request for the inspection of goods to the custom officer on a case-by-case basis if there are reasonable grounds to suspect that the imported, exported, or transited goods infringe their trademark or copyright before the custom officer release the goods out of the custom territory or deliver them to the importer. And now this slide shows the procedures of custom seizures. This slide shows the step for seizing the goods in the case of ex officio action. When the custom department finds goods suspected of counterfeit trademarks or infringing copyrights based on information submitted by the trademark or copyright owners through the TCARS system, the custom department will detain the goods and notify the exporter, importer, or transit operator or their representative that such goods are counterfeit trademark or infringing copyrights. If exporter, importer, transit operator, or their representative admits that the goods are counterfeit trademark or infringing copyrights, or the custom cannot contact such person, the custom officer will record the seizure or arrest and forward the case to the legal department for further legal action according to the custom regulation. Therefore, for this action, it's not necessary for the right holder to verify the goods. But in case the exporter, importer, transit operator, or their representative oppose, they must submit a petition with evidence proving that the goods they intend to import, export, or transit do not infringe any trademark or copyrights within 3 days of receiving the customs officer notification. Upon receiving the opposition, the customs officer will notify the trademark or copyright owner about such arguments. And if the owner wishes to confirm that the goods infringe their trademarks or copyrights, they must submit a confirmation letter and request for legal action within 3 days of receiving the customs officer notification. And if the owner of the trademark or the copyright or their authorized representative wish to request an extension of time to submit a petition to the director of custom or the responsible custom officer, the total extension period of time to confirm the rights must not exceed 10 days from the date of notification by the custom officers. And the director of custom or responsible custom officer may also require a damage guarantee. But based on my experience, I never learned that the custom, they ask for a damage guarantee for this action. And upon verification that the such goods are counterfeit trademark or infringing copyright, the custom officer will then record the seizures or arrest and forward the case to the legal department for further legal action. Now, I would like to show you the recent ex officio action case that occurred in July this year. For this case, the Thai Customs conducted an ex officio raid action at a warehouse located in metropolitan area. Because the customs, they have information about the illegal goods import kept into this warehouse. And during their operation, the customs, they found more than 3,000 items of suspicious counterfeit goods bearing many brands. Following the seizures, the customs contact us as the representative of the brand owners to assist them in verifying the authenticity of the goods. Upon inspection, the items were confirmed to be counterfeit. So this case highlights the proactive role of customs in identifying and intercepting infringing goods, even without a prior request from the right owner. In addition, it demonstrates the ex officio actions can be initiated after the goods have already been imported, not just at the custom port. But in the real practice, although the law allows custom officer to proceed with our verification by the right owner in certain cases, but in practice, as seen in the previous instances, the customs still request the right owner assistance in verifying the detained suspicious goods. In addition, even though the law specifies a 3-day time limit, in practice, customs officers often allow a flexible time limit for the right owner upon request, depending on the circumstances. However, this flexibility is contingent on whether customs can detain the goods based on other legal grounds. So it means that they may not agree with every scenario. It depends on the case by case. And now I would like to move you to the procedures of custom seizures for inspection based on inspection request. For the step in case the owner of the trademark or copyright or their representative has information about goods suspected of being imported, exported, or transited as infringing goods, the IP owner or their representative will submit a letter to request for the inspection of goods to the customs officer on a case-by-case basis. If there are a reasonable grounds to suspect that goods infringe their trademark or copyright, before the customs officer releases the goods out of the customs territory or deliver them to the importer. When the customs officer who received the request for inspection of goods consider the request and the evidence of ownership of the trademark or copyright to be accurate and complete, the customs officer will detain the goods and notify the importer, exporter, transit operator, and their representative when such goods are imported, export, or transit. The IP owners must participate in the inspection of the goods within 24 hours of being notified by the customs. If the IP owner does not participate in the inspection of goods within the specified time, the customs officer will release the goods according to the normal procedure. However, if the IP owner inspects the goods and confirms that the goods infringe their trademark or copyright, they must submit a confirmation of rights and a request for legal action within 3 days of completing the inspection. The customs officer will record the seizures or arrest and forward the case to the legal unit for further legal action. Although the importer, exporter, and transit operators is entitled to file an opposition within 3 days, if the requester file a confirmation of rights and a request for legal action by verifying that the goods infringe their trademark or copyright to the customs within specified time, the customs officer will record the seizures or arrest and forward the case to legal unit for further consideration. If the owner of the trademark or copyright or the representative does not submit a confirmation of rights and request for further legal action within the specified time, the customs officer will release the goods according to the normal procedure. This is show you an example of an inspection request form as outlined in the latest custom notification number 106. The important information that need to be filled in the application form include the details of goods to be imported, exported, or transit through the kingdom, at which office and custom checkpoint, and whether the goods infringe any trademark or copyright. So for this matter, if the brand owner, the authorized the legal representative in Thailand to act on their behalf so they can complete this information on behalf of IP owners. And this slide shows the example of case about the inspection request. This is an example of case initiated through the filing of inspection requests that the case involved about the copyright infringement. One of our clients became aware a container carrying more than 35,000 toothbrushes believed to infringe their intellectual property rights, primarily copyright. The container was shipped from China and was intended to transit through Thailand to its final destination in Laos. For this shipment is arrived at Lam Chabang port before transporting such goods to Laos. And this slide shows the real process of this case that we handle on behalf of clients. As you can see that the IP owner, they have the information about the suspicious infringing goods transited into Thailand prior transporting such goods to Laos. As our client's representative, we submit a formal letter to the director of Lam Chabang Seaport, requesting that the shipment be detained and provide details of shipment in our letter. For next step, after the officer conducted a formality check, they agreed with our request and notify us after the shipment was imported to Lam Chabang Seaport and inform us to inspect such goods within 24 hours after receipt of that notification. In addition, the customs invite the importer to attend the inspection with us. We submit an inspection request to detain the shipment and attend the physical inspection as scheduled by customs. And after that, after opening the shipment, the product appeared to be infringing goods. As a result, we submit a confirmation letter and a petition for prosecution to the customs. And the importer accepts all charges. Accordingly, the customs legal unit imposed the fine. In practice, it usually takes around 1 to 3 months for the fine to be officially issued. And after the importer paid the fine, the seized goods were destroyed and the case was subsequently closed. So now I would like to move to the final stage of this case that the importer agreed to the charge and was fined by the Royal Thai Customs. The fine imposed was more than 200 US dollars. And later, the destruction ceremony was officially arranged by the Royal Thai Customs. All the seized goods in this case were destroyed by incineration at the waste power plant in Nong Kham. And this marks the conclusion of the case with successful enforcement and disposal of the infringing goods to import into Thailand and to Laos. For this slide, I would like to share about the settlement procedures under the Customs Act, commonly referred to as fine punishment. The custom case can often be settled without criminal prosecution. Instead, the offender is given an opportunity to pay a fine, the same as the previous case as I mentioned. Under Section 256 of the Customs Act, if the value of the exhibits, including duties, is less than 400,000 baht, the Director General of Customs shall have a power to settle the case. But if the persons committing offense agree to pay the fines, entering into agreement or bond, or deposit a guarantees as Director General deems fit, the Director General may waive prosecution and the case shall be deemed terminated under the provision of the Criminal Procedure Code. And in the case where the Director General deems fit to prosecute any person under this Act, he shall record a reason wherefore such person should be prosecuted. However, if the value of the exhibit, including the duties, exceeds 400,000 baht, the case settlement committee shall have a power to settle the case. The case settlement committee shall consist of a representative from the Customs Department, the Ministry of Finance, and the Office of National Police. When the case settlement committee has settled any case and an alleged offender paid the fine or enter into an agreement or bond or deposit a guarantee pursuant to the ruling and within a period of time specified by the case settlement committee, the case shall be deemed terminated under the provision of Criminal Procedure Code. So now I would like to hand over back to Kun Sarisa for the next topic.
Next, I will mention about issues concerning patent infringing goods. Throughout this presentation, we have mentioned a lot about trademark and copyright. And what about patent? Unlike trademark and copyright infringement, which can actively enforce under Custom Notification number 106, patent infringing goods are not currently subject to direct custom enforcement in Thailand. This presents a challenge for patent holder as there is no formal recordation system for patent under the TCIRS platform, which is the basis for an ex officio action. However, under the Thai Patent Act, the importation of patented product is the exclusive right of the patent owner. This means that unauthorized importation of patented goods constitute a violation of the patent holder's right. Unauthorized imports may constitute infringement, but enforcement typically falls outside the scope of custom procedures. That said, as the current custom notification does not extend to patent infringing goods, custom officers generally do not seize goods suspected of patent infringement, as it is often challenging to determine patent violations through visual inspection alone. So, what should the patent holder do? They are advised to monitor imports independently and may need to seek assistance from law enforcement or obtain a court injunction to prevent the entry of infringing goods. However, these measures can be difficult to implement in practice. And next is the statistic of annual suppression of infringing goods by custom from 2019 to 2024. This picture is shown here to illustrate the scale of enforcement conducted by custom authorities. They handle nearly 4,800 cases involving over 56 million items of infringing goods. These figures underscore the ongoing commitment to protect IP rights and preventing the circulation of counterfeit and pirated goods. The data highlight the necessity of robust custom procedures and close cooperation between authorities and the right holders. And our last topic is about training event for IP enforcement authorities, particularly custom and police officers. Why is this important? Because effective IP protection depends on how well enforcement officer can identify infringing goods. Many infringing products today are sophisticated imitations, making them difficult to detect without proper training. Training events help equip officers with updated knowledge, practical inspection technique, and real-world case studies, enhancing their confidence and accuracy in handling IP cases. Importantly, right holders who participate in officer training events often gain more visibility and attention from enforcement authorities. This not only facilitates smoother coordination, but also increase the likelihood that their IP right will be prioritized in practice. During the training, the right holder will be personally demonstrate both genuine and counterfeit goods, as well as inspection method. This hand-on approach will help officers gain a deeper understanding compared to receiving the information solely through documents. And kindly note that we offer to conduct training event for IP enforcement authorities at least once a year. So we will be very pleased to have you join us. For this year, 2025, we have already conducted 2 training events. And the first event was conducted on June 10, 2025 in Bangkok. The list of participants are DIP, Custom Department, Economic Crime Suppression Division, Police, ECD, and the police from the Department of Special Investigation, DSI, Metropolitan Police Bureau, Food and Drug Administration, FDA, and Consumer Protection Police Division. All of these authorities are directly involved with the enforcement action. And here are some photos taken at the event in Bangkok. As you can see here, the participants are so many. both the IP holders and the authorities. And you can see here at the desk over here, it can be a display of the genuine goods and the counterfeit good, and the officer will get to see it in person, and they get to touch it, they get to learn how to detect it. And the second event was conducted on June 12th in Udon Thani province. It's in the northeastern part of Thailand. The participants were Custom Office Region 2, which covered 9 ports as shown here, and there are also Udon Thani Provincial Police who joined our training. As you can see, here are some pictures from the event, and that is all event conducted in 2025, and we hope in 2026 we can meet all of you there.
Okay, thank you very much, everyone, for your kind attention. Thank you.
Thank you very much.